I wonder what happened with some people like I can actually hurt somebody a lot.
My lord, my client, Smith is a Navy and has been accustomed to this particular work for 6 and 7 years. On this particular day, which the accident happened, my client was drilling the ground. All of a sudden, a stone fell from the crane and caused severe injuries. I would like to cross-examine my client, Mr. Smith.
Yes, you may proceed.
Mr. Smith, please explain to us what happened on that day.
Thank you. Every time when I saw the crane swing over my head, I would get out of the way by avoiding standing underneath the crane. I always complain about the crane swinging over our heads when we are working because I know it's very dangerous. On that particular day when the incident happened, I was drilling the ground and I didn't notice the crane was above my head until the stone fell on top of me. There was no warning given to me when I was working. So, thank you.
Thank you, Mr. Smith. Therefore, my lord, the defendant by Cross and Sons is responsible for my clients. Mr. Smith injured and the company should compensate for my client's injury. That's all from me, my lord.
My lord, I disagree with the solicitor. Everyone knows that construction site is a dangerous place. Mr. Smith is also mentioned that he knows it is very dangerous. However, he is still willing to take this to working at the place. Therefore, there was no evidence of negligence in the defendants causing the accident. If people will enter into dangerous employment, they do so without making other people liable for injuries they sustain. My lord, I would like to examine the apparent. Yes, you may proceed. Mr. Smith, are you aware of the danger involved in this job?
Yes, my lord.
Thank you for answering my question, Mr. Smith, my lord. Now I would like to call upon my witness, Mr. Hanson. Yes, you may proceed. Mr. Hanson, what caused the disaster and are there any rules in construction sites?
What I know is they put a slingshot on the stone in the ordinary way, but I do not know what caused the disaster. Furthermore, everyone should look at the rule themselves because the rules are stated on the board. It's part of the Mr. Smith's job to look out the rule for himself, and he should have to get out of the way to take care of their own safety.
Thank you, Mr. Hanson, my lord. My CN has done his part in monitoring his employees to be careful and take care of their safety. Therefore, he is not guilty of the incidents happened. In this case, we will rely on the application of the maximum warranty not fit injury and the decision in Thomas v. Quatermain has precluding the appellant from recovering. That's all from us, my lord.
In conclusion, even though the maxim volunti non fit injuria was applied in that the claimant knew it was a dangerous practice and had complained that it was dangerous but still continued. However, there is still negligence conducting to plaintiff's injury because the company had responsible for the injury of the employees. The appeal was allowed. There was no evidence of negligence conducting to plaintiff's injury where the claimant was precluded from recovering as he had willingly accepted the risk. Therefore, the defendant was not guilty. The appeal was allowed. In the previous judgment, the defendant was not guilty because the claimant was precluded from recovering as he had willingly accepted the risk. But the claimant may have been aware of the danger of the job, but he had not consented to the lack of care. Therefore, he was entitled to recover damages.